Hi, I'm Anthony Diosdi. So there's been a lot of talk lately about the IRS accidentally turning off the statute of limitations for individuals to obtain a refund of interest and penalties during a 3.5 year or just over 3 year period of time. So the purpose of today's video is to kind of discuss this and to see if you could take advantage of this. So, how this came about is because of Section 7508A. If there's a disaster declaration, the IRS has the ability to go ahead and kind of turn off certain requirements, like to turn off the requirements to file a tax return or a claim for refund for a period of time during that disaster declaration. Now, prior to 2019, IRS had the total ability to kind of go ahead and determine how long to suspend certain filing requirements. Then in 2019, there was concerns about, I guess it was maybe at least one legislator in a certain southern state that got impacted by a hurricane, and at that point in time, I said, look, the IRS kind of kept a very short period. The IRS extended that window or that period of time for a very short period for people impacted by a disaster. In 2019, Section 7508A was amended. The amendment wound up providing is that if there's a disaster declaration, and a disaster declaration typically happens under the so-called Stratford Act, if the president declares a disaster during that period of time, the IRS doesn't have a choice. They have to go ahead and suspend certain filing requirements. And when I say filing requirements, that means the filing of a tax return. That means the filing of a claim for refund. That means the filing of a petition with the tax court. That means the filing of a suit against the IRS for a refund claim. And Section 7508A also added an additional 60 days. So if there's a disaster that took place after the enactment of the 2019 7508A statute, the IRS had to. They didn't have the authority not to kind of go ahead and waive these filing requirements. Now, when this law was enacted in 2019, people were thinking, or should I say legislators in DC were thinking that this is going to be relatively short periods of time. They were thinking hurricanes in Florida. They were thinking earthquakes or mudslides in California. They were thinking a disaster might last a couple months. So in 2020, along comes COVID, and President Trump issues a disaster declaration under the Stratford Act in March of 2020. Nobody envisioned that's going to last as long as it did. The way COVID hit, it was basically, it came and went in waves. So there was an open presidential disaster declaration that began in March of 2020. And unknown to anybody, the statute was being extended. Now, the IRS at that time issued some notices, and those notices kind of gave the general public a short extension to file a tax return. The IRS stopped the running of interest for a very short period of time. They actually didn't give anybody additional time to file a tax court petition or file a refund claim or file a suit against the IRS. Now, let me pause with this train of thought for a minute, because just prior to this or during this period of time, the federal law regarding how agencies can go ahead and make certain determinations changed dramatically. In the past, there was a Supreme Court case that came out, and the Supreme Court case is entitled Chevron. And what Chevron provided is that agencies such as the IRS and EPA, SEC, they basically were given extreme deference. The courts basically relied on the agencies to be the experts at determining when to go ahead and do what in their sphere. In the past, the IRS, if they issued a rule, a notice, or a regulation under Chevron, unless it basically was arbitrary and capricious, it was upheld by the courts. What the IRS did in 2020 is that they issued a they issued some notices and a regulation itself, but it ran contrary to Section 7508A, at least the 2019 version of it. And nobody really kind of noticed at that point in time that the statute of limitations began to run, or should I say, it started extending the statute of limitations for certain filing requirements and so forth. And no one paid any attention to it. Congress probably got wind of it in 2020. They amended Section 7508A again. And they basically came up with a whole different window as to when the statute of limitations starts to run and ends during a declaration zone. But at the same time, too, Congress specifically said that it's not retroactive, meaning that when the disaster of COVID began to run in March of 2019, or began to tick, so to speak, for purposes of Section 7508A, or that window where the IRS supposedly should stop or delay the filing of tax returns and the assessment of interest and so forth and penalties, it didn't impact that. And it wasn't until recently that a couple court cases came about and basically said the notices and the regulations that the IRS issued ran contrary to law. Now, why did this happen? Well, what wound up happening was there was a Supreme Court case by the name of Loper Bright Enterprise versus Raimondo. And what the Supreme Court said in that decision in Loper v. Bright was that the courts have the determination of whether or not an agency is acting in a way that it's interpreting the laws correctly. And a couple court cases came out and said the IRS is basically, by not extending the statute according to Section 7508A's intent in 2019, it violated the law. So here we are now in a situation where the statute of limitations for the filing of refund claims, the filing of tax court petitions, got told, so to speak, from March of 2020 to July of 2023. So that extended the filing of refund claims or the filing of tax court cases and so forth during this 39-month window. But it goes further than that, because Section 7508A cross-references another statute which states that the IRS has to basically stop the running of interest and penalties during this period of time when there's a disaster declaration. So not only does Section 7508A, the 2019 version of it, extend that filing period, but it basically prevented the IRS from assessing interest and penalties and so forth. So how is that interesting to the taxpayers? Is that if you were assessed for some reason because of the pandemic, you filed the tax return late, and the IRS assessed interest and penalties against you during this 39-month window, you can get that back if you paid it. Or if the IRS assessed penalties and interest against you during this 39-month window, and I say that window, I'm saying from March of 2020 to July of 2023, you now have the ability to contest that additional interest and penalties assessed against you. Now, in some cases, it could be significant. If, let's just say, you're a corporate taxpayer, or let's just say the IRS assessed a significant liability against you. Let's just say if this is a criminal case and you had restitution, the liabilities here in some cases can be significant. So if you were assessed a tax liability in between March of 2020 and July of 2023, and whether you paid it or you did not pay it, you should go ahead and speak to a qualified attorney immediately, because there is a limitation on the period of time that you could actually go ahead and benefit from the new law, or should I say the clarification of 75A, to try either getting your money back, or you can contest that assessment by the IRS. Now, what I'm going to say to you, though, is that the law is not entirely clear for a number of reasons on this. It's not entirely clear if the IRS is going to appeal these trial court decisions. And the other area where the courts have not weighed in on yet is whether or not this 39-month window is a tolling period or not. And when I say tolling period is, let's just say you had a filing requirement that, or let's just say you had a running of interest and penalties that happened before the presidential declaration in March of 2020. It's not entirely clear if this 7508A tolls that and prevents you from making a claim against the government if it was done before this window. So that's something that the courts are going to have to kind of decide. This statute itself is, or Section 7508A, is retroactive or not. But anyway, if you have an assessment of interest and penalties between March of 2020 and July of 2023, you should go ahead and consult with a qualified tax attorney immediately to see what you could do about either getting that money back or reducing that assessment. Thank you very much for your time. As always, today's video is for information and educational purposes only. This does not constitute legal advice and does not create an attorney-client relationship.